Hi, welcome to the online learning module dealing with the employment equity implementation at the University of Cape Town. This module is divided into 3 parts and provides insight into the context of employment equity on a global, national, and organizational level, and more specifically, the key employment equity concepts and the new employment equity policy of the University of Cape Town, which has been effective since 1 March 2021. Part 1. Context for employment equity. Part 1 deals with the context for employment equity, key concepts, and a brief introduction to the EE policy. Why is there a need for EE implementation? And what do we need to consider for this implementation? So the first question that we have to ask ourselves is, why is employment equity still important today, almost 30 years after apartheid laws have been abolished? Yes, colleagues, EE is still an important consideration in our workplaces today as it aims at readdressing the inequalities of the past and creating a workplace that is free of any form of unfair discrimination. EE cannot be discussed or effected without examining or reviewing discrimination and its origins. Our labour market reflects the existing and historical inequalities which have been and continue to be based on unfair discrimination in our society. We also cannot explore EE without distinguishing between equality and equity. This picture of 3 different people of different heights watching a sports game across a fence is a good analogy to illustrate the 2 concepts. It is obvious that not all 3 individuals are initially able to watch the game as effectively as they could due to their different heights. Equality would mean that everyone is given the same chance to watch the game regardless of who they are. If each individual is provided a box to increase their chances of watching the game more effectively, then this doesn't mean that equal opportunities means equal outcome. The tallest person could see the game even without the box. For the middle individual, the box is enough to see the game. But for the shortest individual, 1 box is not enough. Even though they all have been given the same chance, the outcome depends on the individual within their context. Similarly in life, most of us go to school but we get different grades, which is dependent on how much we study or how well we grasp the information, or how much resources we have access to. We won't touch on other variables such as intelligence, talent, wealth, etc. In this scenario, the main variable would be the different heights of the individuals. Equality in this case is giving each individual the same resource, which does not translate to equal outcomes for all. Now let's talk about equity. Equity means that regardless of who you are, you aim to get the same result as everyone. Each of the individuals are therefore provided with the number of boxes required for all of them to have the same outcome. That is, watching the game by looking across the fence. The tallest individual possibly gave his box to the shortest one, or he was never given a box in the first place, or his box was taken away because he was tall enough to see the game without a box. The other 2 individuals were provided with a box or boxes which would allow all of them to get the same result as everyone. The challenge with equity is that it may dampen the drive for the individuals to overcome their current state. In other words, why bother to start work or to start a business when everyone will be promoted or demoted and all will earn the same? Why invest time in improving your life when someone who hasn't done anything will have the same quality of life like yours? You may even lose what you worked so hard for in favor of that other person. Our awareness of the difference between equity and equality is therefore key in our understanding of the implementation of employment equity. Another concept linked to EE and often misunderstood or incorrectly implemented is affirmative action or corrective action. AA measures have generally been implemented with trepidation and received with negativity. This is mostly due to a lack of understanding of what it aims to do and how it should be implemented. It can also be attributed to the fear of or inability to change, or latent or deliberate or unconscious bias. As far back as 1993, Nelson Mandela explained the primary aim of affirmative action, and to quote, "The primary aim of affirmative action must be to redress the imbalances created by apartheid. We are not asking for handouts for anyone, nor are we saying that just as a white skin was a passport to privilege in the past, so a black skin would be the basis of privilege in the future. Nor is it our aim to do away with qualifications. What we are against is not the upholding of standards as such, but the sustaining of barriers to the attainment of standards. The special measures that we envisage to overcome the legacy of past discrimination are not intended to ensure the advancement of unqualified persons, but to see to it that those who have been denied access to qualifications in the past can become qualified now, and that those who have been qualified all along but overlooked because of past discrimination are at last given their due. The first point to be made is that affirmative action must be rooted in principles of justice and equality. If affirmative action measures were implemented as it were intended in the first place, as outlined by this quotation, then we may have been way ahead in terms of implementing and seeing the change our country and organizations requires. We will touch on this in the context of the UCT policy in the next module. South Africa is not unique regarding the challenge of overcoming discrimination and discriminatory practices and implementation of regulations to redress the inequities of the past. Other countries that have found it necessary to implement anti-discriminatory legislation in order to redress the inequities of the past are New Zealand, the UK, Australia, Canada, Angola, Malaysia, Ireland, Zimbabwe, and India. That redress appears to be a challenge. Everywhere is evident from continuous challenges in respect of diversity and inclusion, evidenced in particular by the underrepresentation of Black people, women or persons with disabilities at senior or executive levels in the workplace on a global level. Closer to home, within the higher education sector in South Africa, there is a national challenge of underrepresentation, particularly in the academic track within the professoriate level. At UCT, although at least 83% of employees overall are from designated groups currently, the professoriate remains predominantly underrepresented. That is 70% white and foreign national. The question is, why has it been and is it still a challenge? What role does the institution and groups and individuals within the institution play in effecting change? This is something for all to reflect on. In addition, we need to reflect on the role that our personal conscious and unconscious biases play in continued discriminatory practices that impact our day-to-day interactions and ultimately our workplaces. We need to be aware of how our own conscious and unconscious biases are born out of a history of discriminatory practices, for example, where structural and systemic racism impacted and is entrenched in our psyches. This therefore requires active introspection and action to address and redress on an individual level. Unless we change what is needed on a personal level, we will not be able to effect the change that is required in our institution and our society. Because it is so tightly linked to the transformation process in EE, conscious and unconscious bias is separately dealt with as a learning module presented by the university's Office for Inclusivity and Change, and you are encouraged to register for and attend this workshop. There are several other training courses offered by the university to help us unlearn and raise awareness of hidden isms, such as the disability, anti-racism, and sexual misconduct. Ultimately, though, the courses will present you with the awareness necessary for you to actively address this on a personal level, which then allows us as a university community to break down the barriers to transformation on an institutional and societal level. In order to understand the context of EE in South Africa, we need to consider how apartheid contributed to and shaped inequality and entrenched discrimination in society. Pre-1994, there was systemic exclusion of the majority of South Africans from full participation in the economy. It was based on a system that used race to restrict and severely control access to the economy by Black persons, an accumulation process that restricted wealth creation, imposed underdevelopment of Black communities, and ensured that Black communities were, in the main, suppliers of cheap labor. It was based on discrimination, which is defined as the prejudicial treatment of a person or persons based solely on the membership of a certain group or category, and the actual behavior of excluding or restricting members of one group from opportunities that are available to other groups. It is important to note that unfair discrimination is not only restricted to racial discrimination. Unfair discrimination plays itself out openly and subtly in the form of classism, ageism, and discrimination between well-built and slender people, amongst other things. In addition, today in the COVID-19 era, we are seeing an additional form of unfair discrimination between vaccinated and unvaccinated citizens. In South Africa, therefore, discrimination and inequality were entrenched via socio-political economic change and government-sanctioned legislation, which placed both formal and informal restriction on the entry of what were regarded as subordinate groups through selective inclusion and unequal treatment. Assignment to occupations were based on occupational segregation, race, gender, physical and mental ability or disability, and segregation education and training. It was further entrenched via government-sanctioned segregation within education, housing, and the labour market. The history of discrimination in South Africa and the legislation related to entrenching it dates as far back as the 1800s and continued up until the unbundling of apartheid and the advent of a new democracy in the early 1990s. What is evident is a period of procuring black labour, one of securing white labour, and throughout, that of entrenching apartheid. It can be traced back to have started with the hut taxes and poll taxes in what was then known as Natal, under Law 13 of 1857, which required payment per hut occupied by what was referred to as natives. Natives who lived in European-style houses with only one wife were exempt from the tax. The hut taxes were a type of taxation introduced by British colonists in Africa on a per hut or per household basis. It was variously payable in money, labour, grain, or stock, and benefited the colonial authorities in four related ways. It raised money, it supported the currency, it broadened the cash economy, aiding further development, and it forced Africans to labour in the colonial economy. Households which had survived on and stored their wealth in cattle ranching now sent members to work for the colonialists in order to raise cash with which to pay the tax. The colonial economy depended upon black African labour to build new towns and railways, and in southern Africa to work in the rapidly developing mines. Other key legislation that followed this and aimed at disenfranchising black people in South Africa include Masters and Servants Act 15 of 1856, which was designed to enforce discipline on ex-slaves, peasants, pastoralists, and the rural proletariat. And even though it was regarded as normally colorblind, the penalties were invoked only against darker workers. The Glen Grey Act in 1894, which laid down the rule of one man, one plot in the reserves, excluding property ownership as a voting qualification for Africans. The Natives Land Act of 1913, which formed the basis of other legislation that further entrenched dispossession of African people in segregation of coloured and Indian people. The Natives Urban Areas Act of 1923, which deemed urban areas in South Africa as white and required all black African men in cities and towns to carry around permits called passes at all times. Anyone found without a pass would be arrested immediately and sent to a rural area. It was replaced in 1945 by the Natives Urban Areas Consolidation Act, which imposed influx control on black men and also set up guidelines for removing people deemed to be living idle lives from urban areas. This act outlined requirements for African people's qualification to reside legally in white metropolitan areas. It was only in the 1970s, when South Africa was receiving increasing pressure from both inside and outside of the borders of the country, that the undoing of apartheid started. This increasing pressure continued into the 1980s and 1990s, and eventually led to our first democratic elections in 1994. The undoing of apartheid and the journey of redress via labour legislation started in earnest from 1994, initially with the Occupational Health and Safety Act, in which was followed by various other key acts or legislation. All of these are continuously being amended as required to ensure relevance to and continuous improvement of the labour market and workplace in South Africa. This was followed by the Labour Relations Act 66 of 1995, which legislates fair labour practices, and the South African Constitution of 1996, which requires employers to redress past inequalities as a way to encourage and promote social justice and sharing of the country's wealth. Employment equity or equitable employment in South Africa is specifically legislated by the Employment Equity Act 55 of 1998, which deals with unfair discrimination and guides employers to promote equal opportunity in the workplace and to eliminate unfair discrimination in their employment policies and practices. This means that recruitment procedures and advertising and selection criteria must be fair and based on inherent job requirements that are justifiable and defensible. In the recruitment process, the Employment Equity Act protects job seekers against unfair discrimination and unfair medical and psychometric testing. The Promotion of Equality and Prevention of Unfair Discrimination Act 2000, PEPUDA, or the Equality Act, Act No. 4 of 2000, is a comprehensive South African anti-discrimination law which further prohibits unfair discrimination by the government and by private organizations and individuals and forbids hate speech and harassment. From an international or global perspective, South Africa as a member state of the International Labour Organization, ILO, is required to have in place a policy that protects the rights of individuals to be treated fairly in the workplace to prevent unfair discrimination. On a national level, all companies and organizations or institutions that are deemed to be designated employers are required to implement and report on employment equity in their environments. The Employment Equity Act provides guidance in the form of required phases and steps to designated employers in terms of preparation, implementation, and monitoring of employment equity within organizations, and failure to do so invokes fines and penalties from the Department of Employment and Labour. The EE Act further stipulates that all stakeholders in the organization should be consulted and that this can be effected via a consultative forum or an equitable employment engagement forum, which purpose is essentially to assist in facilitating the input discussion and implementation and monitoring of the EE plan, overseeing the transformation process and educating the rest of the organization in employment equity and diversity awareness. Since 1998, there have been various updates and amendments to the Employment Equity Act. The most significant updates happened in 2014 and later in 2019, include the following shifts. It provided additional grounds for discrimination that relate to a difference in terms and conditions of employment between employees performing the same or substantially the same work or work of equal value that is directly or indirectly based on one or more of the grounds already contemplated in the EEA. Dispute handling in relation to unfair discrimination and prohibited medical and psychological testing are to be handled by the CCMA unless the employee earns in excess of the earnings threshold, in which case the dispute must be referred to the Labour Court. Furthermore, for sexual harassment cases referred to the CCMA, certain arbitration awards can be appealed to the Labour Court. The burden of proof if discrimination alleged is based on Section 6(1), grounds the employer must prove that discrimination did not take place or is rational, not unfair, justifiable, and if discrimination alleged is based on arbitrary grounds, the complainant must prove that the conduct is not rational, the conduct amounts to discrimination, and that the discrimination is unfair. The EU reporting requirements change with a greater focus placed on remuneration, such as the income differentials between the top 10% of earners and bottom 10% of earners, to ensure pay parity and pay equality. The list of employment equity codes of good practice provides detailed guidelines for implementation and covers the following topics. 1. Sexual harassment. 2. Integration of EE into HR policies and practices, Part 1 and Part 2. 3. HIV and AIDS and the world of work. 4. Equal pay for work of equal value. 5. Employment of people with disabilities. And 6. EE plans. In addition, the Employment Equity Regulations provide clarification on the rules applicable to the legal framework of the Employment Equity Act, EEA, where the EEA deals with specific topics. The latest EE Amendment Bill was published by Parliament in February 2021 for public comment. The primary objectives of these amendments are as follows. A. To empower the Minister to regulate the sector-specific EE targets through consultation with the sector stakeholders. B. To reduce the regulatory burden on small employers. And C. To regulate criteria for assessment of compliance to complement the promulgation of Section 53 of the EEA in order to be able to issue Employment Equity Certificate of Compliance as a precondition for designated employers to access state contracts and do business with any organ of the state or public entity. All of these and other labour-related legislation are continuously being amended as required to ensure relevance to and continuous improvement of the workplace in South Africa. Although South Africa has come a long way over these past few decades of working tirelessly to undo the impact of apartheid on our society, much still needs to be done to narrow societal schisms systematically created and, so to speak, level the playing fields which remain a priority in our university and the nation at large. So how does this all impact UCT? In January of 2021, the Vice-Chancellor, Professor Mamokgethi Phakeng, announced that a new era dawns for employment equity implementation at UCT, as UCT presses the reset button on employment equity at the start of the third year of the implementation of the current EE plan, with Council's approval of the revised University Employment Equity Policy for employees coming into effect on the 1st of March 2021. The policy sets the tone and enables the institution to enter a new phase with a fresh approach to employment equity by providing clear definition of key concepts, encapsulating the key principles embedded in EE legislation, underpinning people's decision-making, and it goes further to cover EE implementation guidelines at every stage of employees' life cycle. In other words, pre-entry, entry, engagement, development, retention, exit process groupings in the organization, and includes a dispute resolution mechanism for interpretation of the EE plan. The new EE policy, a 14-pager, replaces the old one, a 2-pager, and can be found on the UCTEE12022021 website, and is to be read in conjunction with the relevant staffing policy governing implementation in the workplace. The policy provides a framework for moving the university towards a clearer, more focused and practical implementation of EE. This is done via the EE policy, the EE plan, the practice notes or guidelines, and institutional and individual commitment. The policy is designed to provide decision makers with the guiding principles to make defensible decisions in a reasonable, fair, and justifiable manner. But even more importantly, to ensure that transformation takes place in pursuit of Vision 2030 of unleashing human potential. The EE policy is unequivocal in its stance on anti-racism, non-sexism, and any other forms of unfair discrimination. Integral to this policy is not only compliance, but also commitment to redress, inclusivity, and diversity. At the heart of our policy is transformation, of which decolonization is a central tenet, and which ultimately every one of the UCT community is responsible and accountable for. We have come to the end of part 1 of this learning module. Part 2 focuses on the UCT EE policy and aims to provide insight into the definitions, principles, and application of the policy. Please complete the quiz to check your understanding before moving on to part 2.